We're going to be looking at ways in which contracts come to an end in this lecture, and we'll see there are four main ways in which contracts may come to an end. The most common way in which a contract would be expected to come to an end is through complete performance. That is to say, parties perform their respective obligations, whatever it was that they had undertaken to do, they do it, and the contract comes to an end. As I said, this is fortunately the most common way in which contracts generally come to an end, parties just fulfilling their obligations. The other way in which a contract may come to an end is just the opposite of performance, which is when a party does not perform. So the time for performance comes, but a party fails to perform or refuses to perform. That is called a breach of contract. So either you would perform or you would not perform. If you do not perform, in general terms, we call that breach of contract. And that can also bring the contract to an end. But there are two other ways in which contracts may also come to an end. One of them is where the parties mutually decide that they do not wish to continue with the contract that they had earlier agreed to do. So A and B, they get into a contract, but subsequently, for whatever reason, they decide not to continue with the contract. That's possible. It was their decision to get into the contract. Law gives them the right to get out of the contract as well. All they have to do is to sign another contract, is to just get into another contract whereby they will decide mutually to bring the original contract to an end. So one contract can bring another contract to an end. And the last way in which a contract may come to an end is by operation of law, where the parties perhaps wish to continue with the contract, but the law considers that circumstances have arisen that make it unjust or unfair for the contract to be allowed to continue. That is, where the law feels perhaps that the contract has become impossible. We'll look at all of these ways in a little bit more detail later, but to summarize, there are four ways in which a contract may come to an end: performance, breach, through another contract, by operation of law. Okay. When we talk of performance of a contract, of course, the performance has to be complete performance. If I agreed to do A, B, C, D under a contract, and you agreed to do F, G, H, I, J, for instance, I need to do each one of A, B, C, and D. And similarly, you need to do each one of E, F, G, H, I. Whatever it is that you had undertaken to do, you need to do. Whatever I had undertaken to do, I need to do. Complete performance. Incomplete performance, as I said, is breach, and usually it is treated as a separate manner in which a contract may come to an end. There are rules where, in some cases, incomplete performance would also get you some compensation even though you failed to perform completely, but that is something that we'll see later. Right now, performance has to be complete performance. If not, it becomes a breach of contract. Now, talking of breach of contract, that is the most important way in which a contract may come to an end for the purposes of your exams and also in real life, because we as lawyers, we hardly ever get cases where breach is not involved. Because look, if parties have performed their respective obligations, there's no need for either of them to come to a lawyer or take the matter to the court. They have performed their contract. Everybody got what they had bargained for. Similarly, if the parties have mutually decided to bring the original contract to an end, they may not wish a lawyer to get involved with that matter, and so therefore certainly they wouldn't wish the matter to be taken to the court because they're mutually deciding to bring the original contract to an end. Operation of law can sometimes see cases going to the court. We'll look at that later. But really, it is breach of contract scenarios that we often find ourselves having to deal with and taking to the court on behalf of our clients. So breach is something that we'll spend a majority of the time in this lecture. Now, to understand breach, let us first understand what it means. There are four distinct ways in which a breach may happen. A party may fail to perform when the time for performance comes. A party may refuse to perform. when the time for performance comes. Or maybe a party performs, but in a defective manner. That is to say, not in line with what the contract had stipulated. So they did perform, but not in line with the contract. That's called defective performance, and that's also a breach. So whether you fail to perform, or you refuse to perform, or you perform defectively, all of these instances are breach of contract. Also, breach happens when you incapacitate yourself from performing a contract. So for example, you were supposed to teach in a school in Karachi, you relocate yourself to the US, and now you're claiming that the contract has become impossible. What are you going to do? You shouldn't be held responsible. Well, you will be held responsible because it was your decision to move to the US, and so therefore you voluntarily incapacitated yourself from performing the contract. The law would not allow you now to claim that you shouldn't be held responsible. If it was your decision, you will be held responsible. Right, so either you incapacitate yourself, or you perform defectively, or you just don't perform, you refuse to perform, or you fail to perform. In all of these instances, you have committed a breach of contract. What are my rights in such a scenario where you have breached the contract? What are the rights of the innocent party? Well, my rights would depend on a couple of factors. Firstly, my right would depend on the nature of your breach. You need to understand that not all types of breach are the same. As you would imagine, in any given contract, not all terms are of equal importance. So some of you might be working, some of you might have some contracts in the past. Consider those contracts. Not all the terms are equally important. So for example, a student who has a contract with an institute, whereby the institute will provide tuition, and in return for that, in consideration for that, the student will pay the fee to that institution. There's a contract there, there's an exchange of consideration. But surely the provision of tuition by the institution is the most important reason why the student went there. There might be other expectations that a student might have. For instance, the student might expect the classes to be reasonably well furnished. The student might expect there to be air conditioners in the class. The student might expect reasonably good faculty at the institution. The student might even expect extracurricular activities to be arranged by the institution, cafeteria services, other gaming activities perhaps at the institute. These are all expectations that students may or may not have. But what I'm saying is the reason why the student went to the institute was not for those extracurricular activities or the gaming activities or the air conditioner. That's not why he went there. He would have air conditioner at his home as well. He went to the institution for tuition. So while there may be 100 reasons, 100 expectations that a student may have from his institution, if you were to ask him what is the most important expectation, if you were to ask him what for him is the most important term of his contract with the institution, he would say provision of tuition. Such important terms of contract are called conditions. In law, we call them conditions. These are terms that go to the root of the contract. That is to say, if these terms are breached, the innocent party would feel that the whole point of getting into the contract pretty much is lost. So by providing him with a reasonably well furnished classroom, or allowing him extracurricular activities is all very good, but if you're not providing tuition, then that's something that the student might feel that that's a breach, a fundamental breach of contract, because it's a breach of a term that to him was fundamental in nature, breach of a condition. If any other term, a minor term for instance, is breached, that is still a breach, should not have happened. But the innocent party cannot now say that it has not gotten any benefit out of the contract. So for example, if the air conditioner was not working on a certain day, or perhaps even for a week, that cannot be said to be such a substantial breach that the innocent party might say that he got nothing under the contract. As long as the tuition was being provided, he did get what he had bargained for. And yes, if provision of air conditioner was part of the contract and it has not been provided, there has been a breach, but it's a minor breach. The reason why we need to distinguish between these two types of breach, minor breach and significant breach, is because of the rights that the innocent party has depends on what type of breach was it. If the breach is of a significant term, or as I said, if the breach is of a condition, we call it a repudiatory breach. The legal term for breach of a significant term, breach of an important value, is repudiatory breach. When repudiatory breach happens, the innocent party has a choice to get out of the contract if he so wishes. So if in your contract with me, let's say, you have breached the contract, and if that breach is a significant breach, that is to say it's a repudiatory breach, I will be given a choice by law whether or not I want to continue with the contract anymore. If I decide that because of your breach I pretty much have lost the essence of the contract, the point because of which I got into this contract is lost now, I may decide that I want to terminate the contract. There's no point for me now to continue with this contract, and the law would allow me that right. That right is called the right to elect to terminate the contract. I would be allowed to elect to terminate the contract on the grounds of repudiatory breach by you. You committed repudiatory breach. I would be asked whether I want to elect to terminate or not. Because it is possible that I might not want to elect to terminate, even though you have committed a serious breach, even though you have committed a breach that pretty much has taken away the value for me under the contract. Because of my own circumstances, because perhaps of paucity of time, because perhaps of whatever reason, I might still decide to continue with the contract, and the law allows me to do that. So essentially what I have is a choice. So when you commit a repudiatory breach, I get a choice. I, the innocent party, will be given a choice. If I want to get out of the contract, I can. If I want to continue with the contract despite your breach, I can. This election is mine. I will be allowed to elect. But once I've been given a reasonable amount of time to think over it, and once I make my election, either to terminate or to continue, I will not be allowed to go back on my election. So this is a decision I need to take after due consideration. I need to think hard about what do I want to do. When you have committed repudiatory breach, I need to decide, do I wish to terminate and consider the consequences of that? Or do I still wish to continue with the contract? We call this continuation of contract as affirmation. So do I wish to affirm the contract? Do I wish to terminate the contract? I will be given a reasonable amount of time to ponder over it. And once I've made that decision would be final. I would not be allowed to go back on it. If I decide to affirm, we will continue with the contract as if nothing has happened. But if I decide to terminate the contract, then our respective obligations will come to an end. This is as far as the contract was to go, and then we will decide what more can be done. For example, I might also want compensation, but as far as contract is concerned, that contract would come to an end. Right, so we have seen the 4 ways in which contracts come to an end, and of those 4 ways we have focused on one, which is breach of contract, and we have seen it's not every breach that leads to termination of contract, but only repudiatory breach, and even repudiatory breach does not automatically bring the contract to an end, but only gives the innocent party a right to elect whether to affirm or to terminate. Right, let us stop here. We'll continue with breach of contract in our subsequent lectures.